Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the high speed dictation. The tribunal in its order has observed that by the earlier order of the tribunal as upheld by the High Court, the disciplinary authority has been mandated to reconsider the quantum of penalty as it cannot impose the penalty of removal from service under the facts and circumstances of the case. The tribunal observed that while admitting the fact that in a number of cases minor penalty was imposed, in some cases censure was imposed, and in certain other exoneration was imposed, the order dated 26th April 2002 has attained finality when the writ petition against the same was dismissed in 2002 and the disciplinary authority has chosen not to move the matter before the apex court. In that event, whatever may be the cause or justification, there is no question of same order of removal from service being passed. The authorities have exceeded the jurisdiction. The impugned order of penalty as well as that of appellate order are therefore liable to be set aside. Learned counsel for the petitioners submitted that the tribunal in its order dated 26th April 2002 has affirmed the inquiry report as well as the order of the disciplinary authority to the extent that the charges levelled against the respondent stood proved. Therefore, the order of the tribunal to this extent has not been set aside or modified by the writ court. Thus, the order of the tribunal to the extent that the charges stood proved attained finality. The only question remained for consideration by the tribunal was that whether on such proved charges what quantum of penalty should be awarded. While remanding back the case, he submitted that the tribunal has not held that the penalty of removal from service is wholly unjustified and should not have been awarded, or some other penalty of removal from service is wholly unjustified and should not have been awarded, or some other penalty would have been awarded. The tribunal has remanded back the case to the disciplinary authority for consideration of the quantum of punishment afresh. It does not mean that the disciplinary authority was prohibited or restrained from levying the penalty of removal of respondent from service. The disciplinary authority on the facts and circumstances and the charges levelled against the respondent having been found proved rightly was of the view that it is a case of embezzlement of public fund and of a misconduct for which appropriate penalty would be the major penalty, that is removal of respondent from service. Therefore, the view of the tribunal that the major penalty of removal from service cannot be passed by the disciplinary authority is not justified. He submitted that the respondent has to follow the procedure provided under rules which specifically provides that the money against any money order is to be delivered at the address after proper verification of his identity, whereas in the present case the same have been delivered not at the place of the address oblique addressee but at the post office itself, and that too without proper verification of the identity of the addressee to a bogus person.